All right, welcome everyone to 2023 Constitution Day in Towson. My name is Juman Kim, Assistant Professor of Political Science and Director of the Program in American Civilization and the faculty organizer of this event. So let me tell you the order of business today really quick. I'm going to introduce the Dean of the College of Liberal Arts, Dr. Chulas, very shortly, and then I'm going to make a brief opening remark on the meaning of the Constitution Day, followed by our two lectures by our distinguished guest speakers. And each lecture will be about 30 minutes, followed by discussion. So the first lecture will be given by our distinguished guest speaker, Dr. Joanna Wist, and Professor Kate Wilkinson, will moderate the discussion with her own questions and comments. And after that, our second guest speaker, Professor Janelle Wong, will give her talk, which will be followed by the discussion led by Professor Jonathan Hensley of Political Science. And after the lectures and discussions, we're going to have a reception just outside in the liberal arts cafe area, and there will be some student activities as well. And Ms. Lawson from the Office of Civic Engagement and Social Responsibility will give you some instructions and some information before you leave the room. Okay, so let me just give a few words of gratitude before I begin. This event is a collaborative work supported by a number of different individuals and a number of different offices, Political Science Department, Women's and Gender Studies Department, Office of Civic Engagement and Social Responsibility, and the College of Liberal Arts Dean's Office. I deeply thank everyone, especially the chair of each department and director of Office of Civic Engagement and Social Responsibility, and of course, our Dean of the Liberal Arts. So let me introduce Dr. Chulas. Dr. Chulas is a historian specializing in Russian history. And he came to Towson in the middle of the pandemic in 2020. And ever since, he has been a leading voice in essentially through his two initiatives, one, Democracy Today, and the other, commemorative events. Those initiatives help us to deepen our understanding of the democracy, inclusion, and the meaning of liberal arts education. And actually, this Constitution Day event is part of his commemorative event. So I deeply thank Dr. Chulas' sustained support and enthusiasm. And with that, I'll take the floor to Dr. Chulas.
Well, thank you, Dr. Kim. People come in. All right, thank you, Dr. Kim, for that introduction and explanation of what to expect in the next maybe hour or so. And thank you to Dr. Kim for organizing this. This is the second year that I know of that you've organized it. Maybe you've done it longer than that. It's a very important moment in our nation's history, but I think it's always important to pause every so often to think about what we value most in a society, and the Constitution should be something that's high up on the list of what we value. So as you've heard, my name is Chris Chulos. I am a historian of 20th century Russia, and I do not study democracy, but I was living abroad for 11 years in different countries, including Russia, Finland, and the United Kingdom. And it was the 1990s at that time, and people were really excited about what the post-Soviet world held. The promise also of the emerging EU. It wasn't called the EU then, but it became a much more expanded European community. And I sat in a lot of conversations, conferences, listened to a lot of papers, talked to colleagues who thought there was only one direction, and that is toward a democratic world. And of course, sadly, we know there's more than one direction. So I'm very grateful that to be able to sponsor an event like this. I was telling our distinguished speakers before we began that the university I came from, more often than not, for Constitution Day, would hand out these free copies, pocket version of the Constitution, because everyone is probably going to carry that around and read it. Of course, they went mostly into the recycle bin. So this is far more meaningful. So I welcome you to expanding We the People, Race, Gender, and Equal Protection of the Laws. Today's gathering is part of the College of Liberal Arts, as you heard, Dean's Commemorative Moments Initiative that recognizes events, themes, and people which are central to the identity of the College of Liberal Arts. Commemorative moments provide the framework to consider and reconsider the values of interdisciplinarity, which to me requires curiosity, creativity, and critical thinking. I usually add confidence in there, but that's a little bit harder for us to teach. We can instill it, but we can't teach that so easily. The values of interdisciplinarity also embody an appreciation for shared common values, as well as different viewpoints and positions. All of these aspects of the liberal arts prioritize inclusion and diversity that enrich the communities in which we live as engaged and informed citizens. For more information about, now this sounds like an ad, but if you want to read more about commemorative moments in my other Dean's Initiative, please go to our website, the college's website, and you'll find it. I want to say a few more words now about the liberal arts. The liberal arts comprise the humanities and social sciences, whose disciplines ask big questions and provide the necessary tools to discover answers and provide solutions relevant to the world we live in. At the core of the exciting work in the college are the faculty and students, like most of you, and of course the faculty, so all of you here, who pose boundary challenging questions with an intellectual flexibility and belief in the dignity of all human beings. The work of the liberal arts is fundamental to the preservation and expansion of principles that support democratic societies. It is our collective responsibility to ensure that those principles, as embodied in the Constitution, in tradition, and our national heritage, remain vibrant and meaningful for many years to come. So again, I would like to thank Dr. Kim for organizing this event. We are honored to have Professor Joanna. Now I asked you beforehand and I'm blanking, Wist, right? Did I say that right? Wust. Say it. Tell me what you're.
It's Wiest.
Wiest. All right. Sorry. I'm sorry. Joanna Wiest and Professor Janelle Wong about the challenges to the Constitution. It's also an honor to have Professor Kate Wilkinson and Professor Jonathan Hensley present to provide commentary on what you will hear. Again, welcome and enjoy the evening. Thank you.
Thank you so much, Dr. Chauvin, for your wonderful welcoming remark. And now I'm just trying to make my opening remark very short. And the theme is, what is the meaning of the Constitution Day? I make it within like 3 minutes or 5 minutes, you'll see. The reason that we celebrate the Constitution Day this way is because it was on September 17, 1787, when delegates to the Philadelphia Constitutional Convention signed the Constitution. Well, to be more precise, they signed the final draft of the Constitution. 12 states, with Rhode Island not participating, appointed initially 70 delegates, but 55 actually attended the meeting. And of those, people say that, no more than 46 delegates in attendance at any one time. And many of them drop out in the middle of the meeting. So only 42 stayed till the end. And of those 42, only 39 signed the final draft of the document. So the day that 39 delegates signed the final draft of the Constitution, that's the Constitution Day we celebrate. But I don't think it is, or it has to be, September 17, 1787, that we truly commemorate nor is the major message was or is the kind of thing that, and close to something like an idolization of those, presumed frames. Rather, I think we truly commemorate, or we seek to commemorate the very proposals, very goals, very purposes of the government so created that the preamble to the Constitution summarizes so well. Anyone remember? The forming a more union, right? And then establishing justice, ensuring domestic tranquility, providing for the common defense, yes, and then promoting what? The general welfare, and most of all, securing blessings of liberty to ourselves and to our posterity. And we also want to remember the history of the we the people, the very entity created by the Constitution, but at once the entity that has been legitimized the very Constitution for time. And we the people, if you think about it, has actually expanded itself and its rights through a number of different means, but mostly through amendment processes. So then it's not just the original Constitution of 1787 that we celebrate, but the Constitution of 1791, which included the Bill of Rights, right? And the Constitution of 1865, which abolished slavery. The Constitution of 1868, which redefined the relationship between national and state governments significantly. And also the Constitution of 1870, 1920, 1964, 1970, 471, each of which struck down or mitigated the existing restrictions on the right to vote on the basis of race, sex, wealth, and age. Right? So fast forward to the year of 2023. What to you and to us is the Constitution? Do you invoke the Constitution as a shield to protect and defend your basic freedoms and rights? Or do you invoke the Constitution as a weapon to attack your political opponents who seem to be imposing false norms and false order on your private and public lives? Or do we need the Constitution because it sanctifies your right, your interest? Or do we need it because we gotta have something to blame when our politics becomes hopeless? Obviously, this is the kind of question that requires a great deal of time and discussion to answer. But luckily, fortunately, we have two outstanding, distinguished guest speakers who help us to advance our understanding of constitutional norms, politics, and rights and freedoms. And now, allow me to introduce our two guest speakers. Our first speaker, Joanna Wist, is assistant professor of politics in Mount Holyoke College, and she writes on law and civil rights, sexuality and gender, and politics of science and health. She earned her PhD from the University of Pennsylvania, and she was a postdoctoral fellow in LGBT studies and lecturer in the Council of the Humanities and Politics at Princeton University. Her book, Born This Way, Science, Citizenship, and Inequality in the American LGBTQ Movement, which, by the way, just came out, right? Tells us the history of the LGBTQ plus rights movement, the modern scientific study of gender and sexuality, and identity politics that form at the nexus. Today, she will give us a talk titled, The Science of LGBTQ Civil Rights. Our second speaker, Professor Janelle Wong, is professor in the Department of Government and Politics and American Studies, and director of the Asian American Studies program at the University of Maryland, College Park. Received her PhD from the Department of Political Science at Yale, and she taught at the University of Southern California prior to joining the faculty at UMD. Professor Wong is the author of many articles and books, including two monographs, Democracy's Promise Immigrants and American Civic Institutions, 2006, and Immigrants, Evangelicals, and Politics in the Era of Demographic Change, 2018. She's the co-author of 3 legal briefs submitted in the Student for Fair Admission versus Harvard case, one of the major decisions of the court during the last term, focusing on social science research to support for race-conscious admissions. She recently published an essay in the LA Times with Vietnam Nguyen, who was one of the esteemed colleagues at USC, of course, titled Affirmative Action Isn't Hurting Asian American. Here's why that means a lot. Today, she'll give us a talk titled The New Racial Politics of Affirmative Action. So now, please join me in welcoming both of our speakers, and I'll turn the floor to Professor Wicks. Thank you.
Okay, well, I want to say I'm so grateful to everyone here at Towson University, and particularly Professor Kim for inviting me to come say a few words on LGBTQ plus equality and the US Constitution. And so we might note from the outset, and maybe it's not much of a surprise, that there's actually no mention of gay or trans or queer equality in the US Constitution. And in fact, there is no mention of sex until the document was already 132 years old. And so then it may seem rather odd to discuss LGBTQ plus civil rights, and particularly victories for those civil rights, in the context of a constitutional commemoration. But in the spirit of expanding the people, or we the people, I want to talk today about how constitutional interpretation changes quite dramatically according to who is doing the interpretation and when in history they're doing that interpretation. And this is related to a concept that some may be familiar with, the living constitutionalism, which is a theory of this normative approach to interpretation that has allowed progressives on the Supreme Court to discern constitutional protections for the most vulnerable in our society. But however, one need not subscribe to that particular normative approach to see how it accurately describes law's inherently political underpinnings. And so if this is how the Constitution does change in meaning, and if at least some of us think that it should change in meaning to include things like LGBTQ plus civil rights, then the next questions might be, how did queer people find their way, at least unevenly, but found their way into this we the people? Next, what evidence and authority did the Supreme Court justices reach for when they decided cases like Lawrence v. Texas, a case from 2003, which protects the right of queer people to be intimate, or Obergefell v. Hodges, which guaranteed marriage equality? And even more pressing today, what might convince the Supreme Court to afford constitutional protections to trans individuals who are today so frequently in the crosshairs of certain policymakers and judges? And so when we search for answers to those questions, we can see a significant role that science and medicine have played in allowing queer people to argue that they deserve to be included in We the People. And what we'll see too is that opponents of that interpretation of We the People have tried to undermine the very scientific and medical expertise that has undergirded many queer rights. And this is all going to have enormous implications for trans youth seeking access to gender-affirming care, to school teachers who teach issues on queer issues and history, and nearly anyone who falls outside of very strict definitions of what it means to be a man or woman, gay or straight, or cis and trans. And so, as Professor Kim said, before I go much further here, a good deal of what I'll be sharing today can be found in my new book, which comes out later this week, actually. And related to this, I must say from the outset that there are many kind of sound criticisms concerning too strong of a reliance on science to achieve civil rights. And what do I mean by that? Well, the United States, of course, has a very long history of justifying brutal denials of citizenship with gestures to science. Biological theories of race, for instance, worked by taxonomizing groups based on phenotypical differences, like skin pigmentation, as well as erroneous notions of ethnic and blood and brain differences. So we can see here a Jim Crow era birth certificate with provisions for categorizing ancestry. And in the late 19th century, regressive medical theories about sexuality and gender difference also flourished. Reproductive organs and sexual practices were used to distinguish full rights-bearing citizens from second-class ones and criminals. So in the book, I recount many criticisms and introduce some of my own misgivings about some of these scientific arguments for civil rights. But that all aside, we cannot understand LGBTQ plus civil rights, its history, and its meaning in the Constitution today without first appreciating the fundamental role that science and medicine have played in expanding liberty and equality. So I want to begin with a little bit of history here. Since the founding of the US, and especially since the late 19th century advent of modern sex and gender science, we've seen state governments in particular exercise their authority to stifle and to punish so-called deviant sexual desires and gender expressions. And we see states have thus wielded their police powers, which is an idea inherited from English common law and protected by the Constitution's 10th Amendment, which basically holds that states have authority to regulate the health, the safety, and the morals of their citizenry. So this is the power, for instance, which gives states mandate over vaccination policies. And so a century ago, states frequently used this police power to shut down early queer nightlife scenes, to arrest gay men for cruising, and to prohibit cross-dressing in public places. And to justify their crackdowns, governments cited sex research warning against the so-called pathological nature of sexuality, or homosexuality rather, and citing its broader threat to the social order. And this science was often promoted by eugenicists, those researchers and policymakers who sought to protect the, quote, good stock of middle-class and wealthy Anglo-Saxon heterosexuals from supposedly degenerate masses. And then in the early 1950s, we see the first modern gay or homophile and lesbian rights movement organizations form with an intent to both change the narrative here, but also the law. And groups like the Madison Society took shape during what was basically a national witch hunt led by Senator Joseph McCarthy, who cast the Democratic Party and the federal government in general as a haven for both communist sympathizers and sexual degenerates alike. And so early in its existence here, the Madison sought counsel from reformist scientists like Alfred Kinsey and psychologist Evelyn Hooker, who argued against the idea that homosexuality was pathological. Kinsey famously called it a normal variant of human sexuality. And we can see this quote by a lesbian civil rights leader in the early activist group, the Daughters of Bilitis, exemplify this activist attitude toward developing and leveraging reform science for civil rights. By the turn of the 1970s, these activists had begun to translate Kinsey's and Hooker's and others' research into challenges against laws premised on the idea that homosexuals were social contagions or that they were violent psychopaths. And instead, they began to argue that gay is good, a corollary of which was gay is healthy, or it is benign. And gradually, even in this early period, gay advocates are going to start to win cases against discriminatory police raids on bars, and even some instances of employment discrimination. Then, in this very important year, 1973, gay rights advocates made a major breakthrough in the world of mental health when they helped convince the American Psychiatric Association to remove homosexuality from its list of disorders. And gay and lesbian activists worked here with a new generation of psychiatrists who sought to move away from an older idea that homosexuality was the product of a poor upbringing by effeminate fathers and overbearing mothers, or perhaps predatory, or to use a word that's popular today in politics, grooming school teachers. And so throughout the 70s and the 80s, after this massive victory in 1973, these relationships between queer advocates and reformers in mental health and medicine expanded and deepened, giving the equal rights movement firepower when they went to courts asking for their civil rights. For one, we start to see advocacy groups begin to integrate appeals to these scientific experts directly into their messaging. And so this is perhaps best exemplified by a 1980s pamphlet distributed by the group Parents, Families, and Friends of Gays and Lesbians, known also as PFLAG. And this pamphlet was titled simply, "Why is My Child Gay?" And the pamphlet and others like it featured all of the opinions and quotes from prominent sex researchers and psychologists of the time. And most of them began to place sexual orientation's origins somewhere between the moment of conception and the first 2 years of a child's life. Just as soon as these scientific appeals began to be very prominent in gay rights campaigns for anti-discrimination laws, they came to be challenged by a budding religious right. And so we see here on the eve of the 1980 Reagan Revolution, there are these conservative activists like former Miss Oklahoma Anita Bryant and a growing movement of other white evangelical groups. They worked to counter gay rights with the rhetoric of choice and lifestyle. And in response, gay rights attorneys invoked biology and science repeatedly in cases involving school teacher rights, child welfare and adoption rights, and sodomy bans. And we can see this, for instance, in a strategy document by one of these gay rights organizations that implored movement attorneys to, quote, address the judge's curiosity and to ask and answer questions such as, what is lesbianism? What is homosexuality? What causes it? So appeals to biology became especially prevalent in cases involving the Equal Protection Clause of the 14th Amendment in the US Constitution. And so in its 1973 decision called Frontiero v. Richardson, the US Supreme Court had granted new civil rights protections to women based on the idea that something called biological sex was, quote, an immutable characteristic determined solely by the accident of birth. Gay rights groups similarly began to argue that sexual orientation was immutable and therefore merited these additional protections under the Equal Protection Clause. So we start to see these in cases dealing with the Equal Protection Clause, but not only that part of the Constitution. Science and medicine was brought to bear on other rights arguments extending from this nascent right to privacy, which is associated with reproductive rights. It was linked to free speech arguments and also arguments against religious establishment. So the idea that the science of sexuality and gender should trump older religious bigotry that was an inappropriate foundation for laws, denying people their equal rights. We even see the gay rights litigation firm Lambda Legal begin to file what it called its Homo 101 brief in all of these cases, which listed rather a long bibliography of every study you could imagine on homosexuality, its nature, its origins at the time. And the brief also dispelled myths about HIV/AIDS and gays and lesbians as well. And so the takeaway here from this early period is that science is being translated into law and into constitutional law, but not merely based on the extant features of that law, but rather because these activists were so invested in growing their bench of experts, and because some judges were willing to listen to those experts. So the 1980s and 1990s then witnessed the deepening of this investment in scientific authority. And during this time, the science itself was becoming increasingly bullish about what it could say about gay identity's nature. So we see with funding from something called the Human Genome Project, geneticists had begun to search in full force for the origins, the genomic origins of sexual orientation. In a 1993 issue of Science, this geneticist Dean Hammer purported to discover evidence of something that soon became called a gay gene. 2 years before that, actually, a neuroscientist named Simon LeVay had similarly championed the discovery of structural brain differences between gay and straight men, which came to be known in media discussions, particularly as the gay brain thesis. And as a result, gay and lesbian rights organizations began to introduce these very strong nature over nurture narratives into their lobbying and litigation and their media statements. So we have some examples here. The American Civil Liberties Union and the National Gay and Lesbian Task Force encouraged their political organizers to explain that, quote, being gay is a matter of choice. It is something you were born with. That group PFLAG commissioned a consultancy group to instruct activists how and when to mention the gay gene in their organizing. And lastly, advocates brought geneticists and neuroscientists to federal trial courts on behalf of military service members who'd been ousted from the military, as well as in cases involving local and state rights restrictions. But courts didn't always bite in this early period on these very strong biological arguments. The Supreme Court, for instance, found multiple means by which to expand civil rights for a time without addressing the science itself. So this happened in 1996's Romer v. Evans, which struck down the discriminatory Colorado state constitutional amendment. Here, Justice Anthony Kennedy wrote that such a display of animus was fundamentally irrational and thus an illegitimate government action per the 14th Amendment's Equal Protection Clause. Additionally, the 2003 case Lawrence v. Texas overturned state sodomy bans without addressing the scientific question. However, during this period, courts were increasingly acknowledging that psychological and public health and sex research more broadly had shifted away from that older perspective that there was anything wrong with being gay or lesbian. And federal courts below the Supreme Court were still discussing the biology of sexual orientation throughout their own opinions in cases concerning military inclusion, for example. And so this is all going to keep the promise of science alive for constitutional rights. And so then throughout the last 2 decades, we've seen biology and mental health expertise remain staples of LGBTQ+ advocacy. And this is perhaps most visible in 3 areas of law: marriage equality, so-called conversion bans or conversion therapy bans, and trans rights. So looking at marriage equality, decades before the Supreme Court made marriage equality the law of the land, we see judges often side with those who portrayed children in gay households as more likely to experience mental distress or to adopt the wrong gender identity. And in cases that led up to the massive civil rights victories of the last decade, advocates and their allies in mental health managed to flip that older scientific script. And that is, they began to convince judges that children of gay couples needed their families to be bonded by marriage in order to best provide for children's mental health and overall well-being. So we see in 2015, Justice Kennedy again enshrined this idea in Obergefell v. Hodges, in which he determined that the Constitution's commitments to due process fundamental liberties, like the right for anyone to marry, and equality and dignity protections for queer people specifically, required marriage equality. And many legal scholars have noted the peculiar approach that Kennedy took to legal analysis here. What is especially notable is that Kennedy used this term immutable, not in its traditional legal sense, but rather to make a scientific argument for marriage rights. And he wrote, quote, that far from seeking to devalue marriage, the petitioners seek it for themselves because of their respect and need for its privileges and responsibilities. And their immutable nature dictates that same-sex marriage is their only real path toward this profound commitment. And then Kennedy cited his sources for this claim in acknowledging that only in more recent years have psychiatrists and others recognized that sexual orientation is both a normal expression of human sexuality and that word again, immutable. And thus the court's marriage equality ruling is based on these scientific ideas about the fundamental compatibility between the nuclear family on the one hand and gay personhood on the other. Beyond marriage, the appeal of science is so great now that state police powers often justify protections for queer youth who face so-called conversion therapy attempts. And in the past decade, legal advocates and mental health professionals working with groups like Born Perfect and Just As They Are have enjoyed enormous victories in banning clinical change efforts for minors. So since 2012, we've seen 22 state governments in over 100 cities have banned these practices for minors. These laws have faced multiple challenges in court, especially by conservative parents who claim that their constitutional rights over their children's lives are obstructed by these bans. But in many of these cases, federal judges have upheld the state's power to govern health and safety against these parental rights claims. And many judges have accepted that gay and trans children are not sick or damaged, but rather that such youth face considerable mental health issues, including trauma and suicide risk, when subjected to these coercive attempts at change. And then we see scientific expertise has recently been adapted to trans rights reforms. And we see there in cases featuring claims of employment discrimination, incarcerated individuals' lack of access to medical treatment, anti-trans bathroom bills, and trans youth healthcare access and sports participation. In all of these different areas of law, we've seen biological evidence and medical opinion playing a prominent role in defending rights. And so as of now, most of the existing victories here are for trans rights have been reinterpretations of existing federal law, like Title VII's employment protections against sex discrimination and Title IX's guarantee of sex equality in education. Some federal courts appear increasingly amenable to granting actual constitutional protections for trans rights. And we've seen, for example, courts use scientific evidence to strike down bathroom bills, and even some of the first trans sports restrictions and gender-affirming care bans. And notably, this judicial route is often used by gay rights activists to fight for constitutional rights, as Congress is polarized and gridlocked and is stalled repeatedly on national civil rights legislation for LGBTQ+ people. So far, I've told a story about constitutional law's gradual transformation and the combined efforts of queer advocates and scientific reformers who have made these transformations possible. But there are still, however, many interpretations of constitutional principles which threaten these nascent civil rights victories. So many opponents of queer rights today craft narratives of competing constitutional rights. And so that is, rather than outright assert that LGBTQ+ personhood has been unduly folded into we the people, these voices declare that religious traditionalists now constitute a vulnerable minority group of their own in need of constitutional protections against queer rights. And so we see here wielding First Amendment free exercise of religion or religious liberty claims, as well as free speech ones. Conservatives have cleverly pitched themselves as the standard bearer of liberal pluralism here. And so as the argument goes, religious traditionalists do not seek to discriminate. Rather, they only wish the freedom to deny service to gay and lesbian shoppers or would-be adoptive and foster parents. And we can see this approach has legs in that the Supreme Court last term, in this case 303 Creative, granted Christian traditionalist wedding website developer to deny services to a queer couple planning their wedding. And in 2021, the Supreme Court allowed a publicly funded religious social service provider the right to deny queer couples the ability to adopt or foster children. And this case, Fulton v. City of Philadelphia here. Conservatives have also argued that the First Amendment protects so-called professional speech of conversion therapists. So here they draw from a 2018 Supreme Court opinion that prohibited California from requiring pro-life pregnancy centers to advertise the availability of state-funded reproductive health resources. And in that opinion, Justice Clarence Thomas explicitly linked such regulations to those banning conversion therapy. And then 2 years later, 2 Trump-appointed justices on the 11th Circuit Court of Appeals ruled against a Florida-based conversion therapy ban on Thomas's logic. Again, on the theme of competing rights, conservatives have pit cis women's rights against trans rights. And so we see groups like the Alliance Defending Freedom, one of the country's most well-funded conservative legal organizations. They have argued that cis women have a right to privacy that would prohibit trans women from accessing women's restrooms, locker rooms, homeless shelters, and prisons facilities. And again, as this argument goes, trans persons deserve basic accommodations, such as a single-stall restroom designated for trans people. But they cannot, for the sake of cis women's hard-won constitutional rights, be allowed into sex-segregated ones that clash with their assigned at birth sex status. And so beyond the competing rights narrative, we also see a return to older state police power arguments against trans rights and reproductive rights. Conservative attorneys and lawmakers here have advanced claims of so-called scientific uncertainty to argue that states must be allowed to protect their population's health against so-called uncertain treatments like gender-affirming healthcare or certain abortion procedures. And here we see them taking inspiration from tobacco and oil industry campaigns against cancer research, against climate change research. And they've done so in arguing that despite all of the evidence amassed for these different practices, that physicians and therapists are just not as certain as they seem about the proper healthcare treatments for trans youth. We can see this message most visibly in science journalist Abigail Schreier's writings that promote very fringe clinical ideas such as rapid onset gender dysphoria. And so these outlier conservative researchers and writers render trans identity as this social contagion, one that corrupts the brains and then the bodies of susceptible teenagers. And so when states ban gender-affirming care for minors, they cite the Supreme Court's 2007 ruling that judges ought to defer to legislatures, quote, where there is medical and scientific uncertainty. And this is despite, again, the fact that every major medical and mental health association in the US and many abroad that work on gender identity care have widely accepted gender-affirming healthcare treatments, such as puberty pausing medications and hormonal replacement therapies for children and adolescents. And even more importantly, all of these organizations oppose legal restrictions on such care. And conversely, when state legislatures find robust medical justifications to ban harmful procedures like conversion therapy, some conservative judges find similar reasons not to defer to those legislatures. So rather than indicating some principled commitment to scientific rigor and evidence-based medicine, these conservative concerns with uncertainty appear largely pretextual. And they are excuses and poorly devised ones at that to withhold best practices of healthcare for sexual and gender minority patients. So given the resurgence of anti-queer campaigns, I want to conclude by thinking about the fragile foundations of modern LGBTQ+ rights and again, how unstable they might actually be. And I say this given the breadth and severity of the broader illiberal threats to the political order, it is quite possible that sexual and gender minorities may once again be stripped of legal protections and again scapegoated for society's ills. As democratic theorist Colin Crouch has argued, a quote, politicized, pessimistic nostalgia can flourish in authoritarian regimes. At home and abroad, so-called populists, and I say so-called because these forces are almost always supported by establishment political figures and millionaire and billionaire donors. They frame progressive sex and gender norms and the rights that have kind of come with these new norms as just another symptom of systemic rot. But some skepticism of such a gloomy outlook is perhaps warranted. Public opinion data indicate a clear secular trend for pro-marriage equality views. And indeed, the increased rate by which Americans are now adopting diverse identities is itself a testament to increased levels of social acceptance, at least until the last few years. And again, because I can't stress this enough, professional medical and mental health associations have come to a robust consensus that coercing an individual to abandon their sexual orientation or withholding gender-affirming care from dysphoric patients are both extremely harmful acts. And in doing so, science and medicine have embraced the value of sexual and gender diversity by reconceiving harm as extending from this mistreatment and this coercion, rather than an inability to adapt to a cis hetero society. However, none of this support is necessarily guaranteed. 21 state governments in the US in the last couple years have implemented bans on gender-affirming care for minors, and that means that about 3 in 10 trans youth are legally barred from accessing potentially life-saving care. And we know from historical experience, even if trans or gay people are not blamed for the ongoing crisis in our politics, someone else likely will be. And so this all has enormous ramifications for how the Constitution is interpreted today and what its meaning might be for the future. And so for all its promise of stability, our Constitution is like any other set of governing rules and principles. Its meaning is contingent on our ideas and our values about equality and liberty and democracy. And so just as these struggles and setbacks and victories for minority rights are likely to endure, so too will this discussion and debate over the nature of LGBTQ+ rights and queer personhood and the meaning of the Constitution rage on. Thank you so much.
Where would you like to be?
Should I stay up here? Sure, sure.
That's fine. And it's someone going to be okay. Thank you so much for that. I wanted to start with a question actually about abortion. Because a lot of what you were talking about in terms of medicine was very much from at least childhood, if not adulthood, right? Questions of gender affirming care for youth, questions of the sexual desires of adults and how those are expressed. But along with sort of other medical changes, there have been rapid changes in reproductive technologies and genetics. Some of those include things like genetic testing of embryos and fetuses, and all sorts of genetic tests can be done on embryos and fetuses. And some of the cases that I've been interested in my own work have to do with the case of fetuses and embryos with Down syndrome, which are routinely aborted at the suggestion of medical experts. And this has become a real issue, not just with sort of pro-life groups, but with disability rights groups. And I wanted to know your thoughts on sort of the future of those the role of those kinds of reproductive technologies should the so-called gay gene or trans gene or whatever gene might be involved, should it be found and should it be editable, as some genes now are editable.
Oh, it's so fascinating. Thank you so much for that question. Where do I want to start with it? Well, in the context of a short talk, I don't get to say what I really think about some of this genetic research on the origins of sexual orientation and of trans personhood. And we need to clearly separate out two kinds of arguments here. The one is that we know something about the genetic origins of these identities, and the other is that we know that it is beneficial to give folks gender-affirming care when they say they need it, and to avoid coercing people to give up identities that they feel are kind of deeply part of themselves. So on the former question, there is very little genetic evidence that there is such thing as a gay gene. There are various different studies. Geneticists don't look for a singular gay gene that would map from genotype to phenotype any longer. So from you have one gene that codes for your gay identity or your straight identity. This is not the way that geneticists think about any complex human trait or identity these days. And there are studies that suggest that there is potentially a small amount of genetic inheritance, 8 to 24% at best, that can be accounted for when we think about the genetic origins of gay identity. And of that 8 to 24%, scientists have found locations actually in the genome accounting for less than 1% of that variation, so less than 1% of 8 to 24%. This is all to say we don't have a lot of evidence that we could ever edit an embryo for something like gay identity or trans identity. So I think folks bring up this fear oftentimes, but I think it's not likely. I think we're more likely going to have to balance disabilities rights and reproductive rights and ensure that the disability question doesn't provide kind of a justification for eroding reproductive rights entirely. But I think for the sexual orientation and the gender identity question, it's less of a threat. And I should say, to finish that thought out actually, that I think the much stronger scientific claims that we have are the ones that suggest that there is a ton of suicide risk, there's a ton of trauma risk if you withhold gender-affirming care with these so-called gender-affirming care bans, and if you don't prohibit conversion therapy, particularly for minors. That is where we have the most robust evidence base. And what's nice about those is we don't have to say we know something about the complex origins of someone's identity. We just have to know that if you punch someone and they say it hurts, you should believe them.
I have a question about bisexual erasure in all of this research and the arguments. Like where has bisexuality sat in these various spaces of research and rights arguments?
Yeah, so I think it's a good question. For a very long time, there was this idea that searching for genetic origin stories for gay or lesbian identity would forever preclude us of finding certain, looking for and making the kinds of rights arguments for bisexual people and for trans people. I think with some exceptions, that's actually not the case that we've seen over the last 2 decades. I think in the past, but especially in the last couple of decades, we've seen actually a lot of bisexual research, particularly research that's caused a lot of problems. There was this kind of on again, off again saga where these sexual orientation researchers were studying bisexual people, and they first published this big study that said bisexuality doesn't exist. Your gay, straight, or lying was the New York Times headline for when that research came out. But then there was more funding placed into these particular researchers, research kind of grant monies. They worked with bisexual activists and advocates, and then lo and behold, several years later, they found evidence for bisexuality. And so that actually made some bisexual advocates quite mad, because some people who adhere to kind of or say, you know, that they identify as bisexual say the whole point is that it's not fixed, it's flexible, it doesn't we're on the outside of these rigid either or arguments. And so it became this kind of whole kind of intra-activist and scientific kind of dispute that repeatedly made its way onto the headlines of the New York Times. And so I think we've definitely seen that that bisexual identities can be included in this narrative, but then the question is also, how many people who have that identity want to be included in, again, this kind of rigid born this way narrative? And some not so much, I guess.
Go sort of this direction.
I wanted to take on, you know, like how people say like there's only like two genders. So what's your take on people not being as a gender? Because like you know how like now like you can like pick which one are you like who you identify as, you know, non-binary. So like how do you feel when people like you as non-binary?
Yeah, it's a fascinating question. I was tempted to give the Joe Biden answer, which is that there are at least 3 genders, right? In response to how many genders there are. There are at least 3. But the thing about the argument about there are only 2 genders, for instance, relies on this notion about what biological sex is. And biological sex is actually more complicated than just you are born female or you are born male. It's a combination of different characteristics, and then we take the average of those to say you are male or you are female. We can categorize you as such. But there are different kind of chromosomal patterns that we use to define that. We define that based on genitalia. We define that based on hormone levels, which can actually vary quite a bit more than what we deem averages for male and female. And so I think when people start to question how many genders actually are there, we need to say first, we're probably thinking about an older model of biological sex as something that's either or in the first instance. And then that gender is something that's not exactly mapping on to that kind of binary distinction, right? And so non-binary isn't necessarily something that you can see under a microscope, right? But it's also, it's part of the autonomy of the person to identify that way if they want to. And so I think some of these rights arguments are about creating space, not to say, okay, there's 5 new ways that you can be and you have to slot yourself into those new ways, but rather to say, why do we care about policing those categories? And why can't we expand the autonomy for people to identify in identities like non-binary, but many others as well?
Yes, sir.
Yeah, earlier on in your presentation, you mentioned free speech, so I'd like to ask you, do you personally believe that people should be required legally to affirm the beliefs of, affirm the identities of LGBTQ plus individuals?
To legally affirm.
Do you believe people should be legally required to affirm the identities of LGBTQ plus individuals?
Well, I think you hear this argument a lot, and it's posited as if there is kind of one reading of the First Amendment or one reading of a law that says that in every circumstance where you ever are, that you must affirm the identity of someone who says they identify that way. But this isn't the way actually our political environment works at all, right? I mean, if you are a school teacher and you are charged with respecting your students and engaging in appropriate pedagogy and creating a respectful classroom, maybe that's an instance in which you should have to affirm the identities of people. And that's something that courts have kind of debated. But I think, again, sometimes there's this idea that soon there's going to be this legal mandate where everyone has to affirm each other's identities, whoever they say they are. And we have a lot of free speech in this country. And so private individuals don't generally have to acknowledge anyone's identity. We could talk about ethics and norms that we want to see in the world, but in terms of legal prohibitions, the First Amendment protects your right to say quite a lot.
Hi, I thought the
topic where you talk about conservatives and science in the Constitution and how like members of the Supreme Court would kind of use the Constitution's language and things to discriminate members of the LGBTQ plus community. So I guess my question is, how do you think that these like kinds of decisions and that rhetoric in the Supreme Court are gonna like affect future Supreme Court decisions and members of the LGBTQ plus community?
Yes, so I mentioned that there had been a lower federal court that had struck down a conversion therapy ban based on this kind of more conservative reading of professional speech. We care more about the conversion therapist's ability to coerce someone to change their identity than we do the person who is being coerced, the LGBTQ plus minor. And federal courts below the Supreme Court, the circuit courts of appeal, they're split on this question. There are a few different cases that have come to different conclusions, some supporting bans, some opposing bans. And the Supreme Court could, it's not necessarily going to happen, but they could any day now say, we're going to take up a case that deals with the fundamental constitutionality of conversion therapy bans. And I think that is something to look for on the horizon of how far these conservative rights arguments might go.
I just have a question about like the relationship between science, especially medical science, and the public opinion. Because I sense a kind of like conflicting within your argument is, on the one hand, the liberals and the LGBTQ community have resorted to science to buttress their arguments about right to support and expand civil rights. But on the other hand, especially recently, the conservative communities has also used the science to provide alternative narrative. But as we have all know that science is always shifting, right? And it's a consensus that has been reached by the academic community could shift dramatically over decades. The reason why at the beginning of the 20th century, science has been used to curb and persecute LGBTQ community, all right? So the homosexuality was defined as a kind of mental illness. The conclusion drawn by the medical community. So I'm just curious, because what if like what if there was a shift in scientific consensus regarding the current consensus about the LGBTQ communities? For example, at the end, you have referred to the scientific community as a kind of external authority to validate the argument. What if these communities have a different opinion as new findings emerge? So how do we reconcile with this kind of rift between the science on the one hand and our societies who have different opinions?
Yes. I really love this question, because I think what it gets to the core of is that science is not something that exists outside of these changing ideas about what it means to be a certain way, right? And one of the reasons that the science has changed is because we've shifted our idea about what is the harm that we're interested in. And so that indicates that there is a social process here, that science is something that's not this thing divorced from our politics and divorced from our society, but rather that it's part of it, right? And the science has changed because the vast majority of mental health professionals and physicians have concluded that they are more interested in the trauma risks, the suicidality risks, and those sorts of harms that befall LGBTQ plus people who are not kind of treated in these particular ways, more than they're concerned with the past model, where psychiatrists saw their duty oftentimes to make sure that this gay man who had a wife and kids could fit the way that he was supposed to be in society as it existed then, right? And so that's where we see this difference of harm. Is it the harm to this individual and to kind of this cis heterosexual society, or now we have this this new conception of what we're actually interested in terms of what constitutes health, what constitutes harm. And so again, the idea there is that the science has changed because our values have changed as well. It's not just our values. We have lots of robust evidence that you could say is more or less objective. But it's objective because it's pointed toward these new concerns that we have. And so again, I think the science itself has a fundamental kind of social element to it.
Do you have any questions on this? Legitimate questions?
Just remind me that you use Q&A.
The gentleman that,
Yeah.
Yeah, I guess in a similar vein, for when you're using like scientific studies and evidence as kind of basis for an argument, is there any sort of criteria that a study has to meet to be valid evidence?
Yes, it's a great question. So federal courts have devised their kind of own rules for this since the advent of kind of what we think of as modern science in the late 19th and early 20th century. And basically, courts ask when they're presented with evidence, where they're presented with a purported expert before them, they ask whether that person represents the mainstream of their particular scientific discipline. And so they'll look, they say, like, if you are if you're claiming to be an expert on gender affirming care for youth, are you a pediatrician? Do you have experience treating trans kids, et cetera, et cetera? And that notion of being in the consensus, you can have competing views within it, but you can't be kind of on the fringe and out the outside. And what happens in a lot of these gender affirming care ban cases is that the LGBTQ plus rights groups that want to oppose the bans will bring their experts, and those experts will be the kind of heads of some of these societies, like the Endocrine Society, like any one of these organizations here. And I've been studying this, and the vast majority of experts that the proponents of bans on gender affirming care for minors will bring do not have experience with gender identity medicine. Most of them are not pediatricians. They are often people who study pedophilia. They are people who sometimes are plastic surgeons, for instance, but they're plastic surgeons who only work with adults in their kind of clinic in a suburban mall outlet strip or something like that. So when judges are met with that sort of thing, they can deem, you know, this is legitimate science and this is not.
Thank you so much.
Thank you.
thank you.
All right, I want to thank Dr. Kim and also the college, and thank you to Dr. Hensley for being here to moderate this panel, staying late on a Monday. I'm here to talk. How many of you have been following or have heard anything about affirmative action in the last 2 months? All right. So I have been part of this case, SFFA versus Harvard, for the past 5 years. And so I've co-authored briefs with my colleagues. We're standing here in front of the Supreme Court, and our briefs were about how social science supports race-conscious admissions. So we were defending affirmative action. The case is really about this, it's a Title VI case, and I'm going to dive into it a little bit more in a minute. But let me just say this, that for more than 40 years, the court has determined that affirmative action, race-conscious admissions do not violate Title VI. So constitutional law requires that the use of race in public policy meet the strict scrutiny requirement. That is, it must be narrowly tailored to serve a compelling group interest. So case law has allowed the consideration of race and admissions for all of your lifetimes, with the following limitations. 1, race cannot be used to set quotas. So many people in kind of an everyday way of thinking about affirmative action think that race is used to set a quota for admissions, but that has been out of practice, not used since 1978. No university can do that or it would have been sued. So there are no quotas in admissions based on race. In addition, in 2003, shortly after most of you were born, or maybe during, many of you were born probably. How many of you were born after 2003? Okay, so over your lifetimes, race has also not been allowed. You can't use race as to set a point system, or it can't be a preference in a single preference, the most important preference in college admissions. How was race used? And it's sad that we have to use this in the past tense right now. So race could be used as a factor of a factor to allow colleges and universities to meet their mission, their educational mission. So a lot of people are a little bit confused sometimes about how race is used. Race can be considered, that has been the law, but never as the primary, never as the only factor. That's how universities and colleges comply with this narrowly tailored requirement. That mission, the reason, the constitutional justification for the use of race in college admissions has not been to address past or present discrimination. What the court has allowed is that the constitutional justification is diversity. It is to benefit the students on that campus. So that really, really restricted how race has been used in admissions. So what this case was about is a complaint that Harvard and UNC, University of North Carolina, violated the 1965 Civil Rights Act by discriminating against Asian Americans in their admissions policies. And I'll talk a little bit more about that. So this case centered on Asian Americans. Who is SFFA? I keep saying SFFA, Students for Fair Admissions. That's the group that sued Harvard and then sued UNC and also complained about Yale's admissions, right? SFFA is a group called Students for Fair Admissions, and it is really run by one person, Edward Blum. Edward Blum actually then brought on one other person, Abigail Fisher, who is a white woman that he represented as a plaintiff in an earlier affirmative action case against University of Texas. Edward Blum is very well known to the Supreme Court. Edward Blum has attacked voting rights and was successful in what many say gutting the Voting Rights Act by removing a really key provision in the Voting Rights Act that required those places that had discriminated against people of color in their jurisdiction before they no longer, because of Edward Blum, had to go through a process where any change to their voting systems or their voting procedures were reviewed. That really weakened voting rights. He also attempted, but was not successful in challenging immigrant political representation in a case called Evenwald. And so Edward Blum is very well known to the Supreme Court. The Trump administration supported his position in this case. So even though this case was about Asian Americans, it was actually led by this man. And Edward Blum is not a lawyer. He's a legal activist. Very, very effective legal activist, I will say. And prior to this case that made headlines in the last 2 months, Blum had sued the University of Texas over their affirmative action, race-conscious admissions plans. In those cases, he said that this white woman, Abigail Fisher, faced reverse discrimination, that she was penalized for because affirmative action discriminated against her in favor of students of color. After failing to fully destroy affirmative action, Edward Blum stated publicly at this dinner in Texas that he had to find an Asian American plaintiff. Why did he have to find an Asian American plaintiff? What's the logic there? Any ideas? Yep.
Asian Americans as a minority, they have done great academic performance, and they believe they have been punished by it.
So he selected an Asian, he really was looking out for an Asian American plaintiff because Edward Blum, because of this past legal action he'd taken, was always being accused of white supremacy. But in this case, he said, well, I'm going to defend Asian Americans. It's a group that has faced racial discrimination. And so I'm going to be able to shield myself from charges of white supremacy and racial discrimination. I'm actually defending a group that has faced discrimination. So this is something we're going to come back to. But the question then becomes, have Asian Americans faced discrimination in the college admissions process? 2 lower courts said no, and they looked at a lot of data, but the Supreme Court said yes. Let's take a closer look. And what I think this means, this case is broader than the details of this particular round of litigation. It's really about a new racial politics in the US. And as you say, the case relies on an Asian penalty narrative. So some of you may be familiar with this narrative, that Asian Americans must score higher than other groups on standardized tests to be admitted to selective institutions. How many of you have heard that? Where did you hear that? It's like in the air, right? It's in the air. That Asian Americans faced bias on something that was called the personal rating, and that there was a cap on Asian American admissions. This is what SFFA claimed in every level of the case, and what 2 lower level courts rejected. And throughout the case, even though SFFA said that this case was about protecting Asian Americans, the way that SFFA proposed a remedy was to say, okay, the only remedy here is to remove the consideration of race altogether from admissions. No more affirmative action is what SFFA proposed. Let me just say that not one Asian American testified in court to discrimination. So that tells you a little bit about the racial politics that I'm going to dive into here. On the other hand, Asian American students did testify defending race-conscious admissions at Harvard. So there were Asian American plaintiffs in the case represented by SFFA. They remained anonymous. They never testified. So SFFA threw all the data it could at this case, but mainly it threw a very tenacious narrative at this case, something that some of you have already said you're familiar with, right? The idea that Asian Americans work hard, value education more than their peers, that they have a special value for education above and beyond other groups, including white Americans. That was what SFFA brought to court. I call this case the model minority goes to court. And this was one of the most popular kinds of memes that went around with this case. The model minority myth is built on this kind of statistics, that Asians must score 140 points higher on the SAT than whites to get into elite colleges. How many of you have heard something like that? Seen something like this? It really is popular on Chinese ethnic media. Okay, this is where I've seen it. However, if you look more deeply at the study on which that statistic is based upon, there is no way to conclude that Asian Americans must score this percentage point increase over other groups, because that's a misinterpretation of the data. This is not a fully specified model. Thomas Espenshade, if you read the whole book, and his colleague, they presented a model of college admissions based on some data, but they didn't have the complete application files. So all they had was what students reported on a survey. They did not have the letters of recommendation. They do not have the college essays. And so it's an incomplete set of data. And then it's an incomplete, the estimate is based on an incomplete set of data. Dr. Espenshade himself has said, these data are not strong enough to be considered a smoking gun with regard to discrimination. Even in places where race is banned, like California, there's a gap in test scores between Asian Americans and other groups. And that's for other reasons, which I discuss in another talk, having to do with immigration laws and other ways in which Asian Americans have been hyper-selected to the US in many cases. In addition, what do tests measure? This is the primary data in the case, but the SAT is not the best predictor of first-year college grades. So research shows that it predicts maybe 12 or 13% of variation in the first year. And for whatever reason, 20 years of research in education has shown that after the first year, going into the second, third, and fourth years, the SAT barely, the predictive value of the SAT starts to decline even more dramatically. So it's actually not a great measure of whether someone will succeed in college. It is highly correlated with what? SAT scores. Parental wealth and parental education. That is what the SAT is really good at telling you something about. Whether your parents are highly educated and whether your parents are wealthy. How many of you would use those two factors as college admission criteria? So the model minority stereotype is very harmful because it also makes an assumption that all Asian Americans are huge academic achievers, when in fact we know there are low-income Asian Americans. There are also groups that have traditionally not been high achievers on test scores, because most of those groups, those Asian American groups, while they're Asian American, have come to the US via, let's say, refugee resettlement policies. Right? We see mass variation within the Asian American community. It's harmful for many other reasons, but there are some ways in which the model minority stereotype does advantage Asian Americans in a way that no other racial group experiences. And that is that teachers, for instance, have higher expectations of Asian Americans because they themselves buy into the model minority stereotype. And this has actually been shown to improve student test scores, these high expectations. So if you look at teacher bias data and you look at students, compare the way that they attend to Asian American students in their class and white students in their class, compared to Black and Latine students who have the same homework practices, have the same GPAs and the same test scores, teachers will call on those students more, and they will promote those students more into, let's say, AP classes. That is something that this case did not take into account. The way in which, yes, Asian Americans face implicit bias, but that implicit bias cuts both ways for Asian Americans in a way that other groups of color don't benefit from. Okay, so this is one of the things that in the academic research that we included in our briefs, we really underscored that this model minority stereotype, while it is harmful to Asian Americans, the idea that Asian Americans care more about education than any other group, that stereotype also leads to actual better outcomes for Asian Americans. So that's a small slice of what some of the critiques were of the idea that Asian Americans were more deserving of admission than other groups based on test scores. Test scores can be critiqued, should be critiqued. In fact, the UC system has dropped the SAT from standardized tests, from admissions, because it was found to be racially discriminatory. This is the other part of the case, which is the personality score. So Harvard has 5 different scores. One is a personal rating. This is actually not, this headline shows how the media took up this score. They called it a personality rating. It's actually a personal score. The personal score is not a personality test, and it does not gauge whether someone, like your reviewer, thought you were charismatic or charming. It's actually everything that was not in the other measures. So it includes things like your choice of major. It includes things like the evaluation of your letters of recommendation. So many Asian Americans saw, oops, sorry. Where's? So many Asian Americans saw those headlines, and I would count myself among this group, and we're like, oh no, right? We're facing discrimination also based on the model minority stereotype. Maybe we're being stereotyped as like not very good leaders, just like nerds who want to study but don't have other qualities. But in reviewing the documents for this case, the courts found no discrimination. And there was some pretty compelling evidence that Asian Americans were not facing discrimination with regard to the personal score. First, Harvard's expert, who is a Nobel Prize-winning economist, did further analysis of the data and found that Asian American applicants from California, both men and women, were actually scoring higher on the personal rating than other students. And this brought up some questions, because what kind of nefarious discrimination scheme would not affect Asian Americans from California? So when you look at that group, guess who sends the largest number of applications to Harvard? Which state? California. I don't know if it's the largest number, but it's really high, right? So that was one kind of question in the case. A second was that if you just looked at those who identified as female in the applicant pool and Asian American, their personal scores, there was like an unexplained boost in their personal scores, net of other factors, right? What kind of intentional discrimination scheme would not affect Asian American women and would affect Asian American men? In addition, Asian American legacies, if you look at the full court case, Asian American legacies were actually being admitted to Harvard at higher rates than white legacies. Again, what kind of discrimination, intentional discrimination scheme would lead to that outcome? And this, I thought, was one of the most interesting pieces in the case, that SFFA said that Asian American, the small number of applications that they reviewed show that Asian Americans, and they highlighted this in the media, Asian American students had these kinds of comments on their admission files from the reviewers. Very quiet and strong. In fact, and that does align with the model minority stereotype. But what they didn't say is that white, Latine, and Black applicants also had those same comments on their files. In addition, this is the year that was in question, the 2013-14 interviewer handbook, that is part of the evidence for this case, reminds alumni to appreciate introspection and the reflective introvert, as well as that more bold future leader. So again, if you take a quick look at this case and you start to question the model minority stereotype and how it's deployed in this case, you might come away with a different conclusion than Asian Americans face discrimination. It's not that clear. So here are some other kinds of data points that I think don't make it very far outside of those who are following this case. But you can see here, universities that practice affirmative action, especially these highly selective institutions, saw a greater increase in Asian American admission rates than the UCs where affirmative action was banned. In addition, you can see here, there was this idea that there was a cap on admissions, but what you see here is that the Asian American admit rate fluctuates over time. It's up and down, but it's mostly up. That doesn't look like a cap to me. What proportion of Asian American of the population are Asian American students? Over 10% or under 10%? If you think under 10%, raise your hand. Over 10%. No, it's under 10%. Asian American students overall are about like 7% of the population. Look at this admission rate, 22.7 at Harvard. So how many of you have heard this kind of advice that maybe an admissions counselor will give to Asian Americans? Don't check the Asian box. How many of you have been told that? Okay, why do admissions counselors say that? Because they assume that there's a penalty, right, against Asian Americans when Asian Americans are applying. But I think this is really a dangerous kind of advice that Asian American students get, because under holistic admissions at Harvard, right, we saw that Asian Americans were in the last 2 years, they were more than 25% of Harvard admits. How do we know that? Because they checked the box, okay? And they got into Harvard. Checking the Asian American box did not mean they didn't get into Harvard. So I think this is actually a false myth that if you check the box, you're not going to get into Harvard. We know that's not true. And it's actually a scare tactic used by college counselors and especially private admissions professionals to get money from Asian American communities. So all of that doesn't matter anymore because the Supreme Court already made a ruling, okay? So the Supreme Court didn't buy everything that I just said. I just want you to be thinking about some of the counter evidence that SFFA, that challenges the assumptions that SFFA made and challenges the idea that Asian Americans face discrimination in college admissions. In fact, holistic admissions have been working very well for Asian Americans, or we wouldn't see those kinds of admit numbers at a place like Harvard. How many of you saw this kind of headline in June? The Supreme Court strikes down affirmative action, banning colleges from using race in admissions. Okay, most people, when they saw these headlines, they saw this, strikes down, ban, okay? And they were like, oh my gosh, we can't use race in admissions anymore. It's not true. race cannot be used in the way that Harvard and UNC were using it. So this is the part of the headline that was less clear. The Supreme Court strikes down affirmative action, banning colleges from factoring race in admissions, factoring race in this constitutional way that race had been permitted to be factored in. What does that look like? You know, I teach at UMD. So this is UMD's factors, okay? It is true. UMD can no longer use race and ethnicity as in a list among the factors that they consider. It cannot be a separate factor, even though, remember what I said, race was never at UMD the only factor, the primary factor, never in the last 40 years. It is one of many factors, and it could only be used in a very subtle way. So in the Supreme Court opinion, what we see is a narrowing of how race can be used. So in the Post decision, race can't be a separate factor in a list of factors. That is, in fact, banned. But the consideration of race altogether has not been banned. It has been narrowed. So actually, I'll show you this in a minute. A university can actually have an essay that asks people about how race has mattered for their experience and what they will bring to a university. The consideration of race outside of admissions was not banned. Okay, so universities right now are reviewing their scholarships, reviewing their financial aid, and reviewing their admissions. But the Supreme Court decision begins and ends at admissions. There is no guidance in that decision about scholarships or financial aid. So to me, that is an unnecessary overreach to go in. My university said, review your websites. Based on what are we reviewing? Because the Supreme Court decision says nothing about what to do with your websites or the keywords that shouldn't be there. So colleges and universities can only think about, they must be trying to look for words like race and diversity, right? And to me, that is dangerously chilling. In addition, the collection of data on race has not been banned. We still need to collect those data because we still need to enforce anti-discrimination laws. So here you can see the majority opinion states nothing in this opinion should be construed as prohibiting universities from considering an applicant's discussion of how race affected his or her life. Okay, this means that universities can ask a question that gets at this very topic. That is not banned. People can still talk about race. Here's my university's guidelines. And again, it says affected programs should review and update their recruitment, admissions, and scholarship awards. Many of you might have seen this. This is not required by the Supreme Court decision. Only admissions is affected, and still students can talk about race. Collection of data on race. Again, this is not banned. We still must collect data on race in order to ensure there are not civil rights violations on our campuses. In California, after a ban on affirmative action, they actually doubled down on high quality, detailed data collection. Let me show you what their post-affirmative action data collection looked like. They went all in, okay? Yes, they face a ban on affirmative action. They collect these data. Why do they collect these data? At the moment of admissions, because they're trying to see where can we do better in terms of outreach, recruitment, and support. So don't let your university start to back off on data collection. This is an important tool. So I'm going to wrap here by saying and provide some broader context. This is part of a much larger political struggle over racial equity. And the fact that universities are rolling back so many more programs than are specified in the decision is a chilling effect that SFFA was trying to achieve from the moment it brought these cases. It's also really important to hold the line here because SFFA is not the only legal player in town. I was part of a group, as I said, that actually sued the UCs for using the SAT. And that is an additional pressure because we said that the use of the SAT was racially discriminatory and led to unequal access to UCs. And they do not have the SAT anymore. Many universities are starting to also have to review their legacy policies, right? Because there is political pressure on both sides, not just conservatives. So I'll just end by bringing us back to what is this new racial politics? Weaponizing Asian Americans and the model minority myth is a new legal strategy that's going to extend way beyond this decision. There are public high schools in Virginia, Maryland, and New York City, where again, Asian American parents represented by a white legal firm, and I say white because the 4 executives at the top of this legal firm called Pacific Legal Foundation, that's who's providing pro bono legal representation. They're representing Asian American parents, and they're suing over race-neutral reforms to magnet school admissions. Things like a percent plan that select the top 1.2% of all the middle schools to go into a high school. And that's being challenged as anti-Asian. So this is something that I think is reshaping race relations in the US. And I'll just say, because I didn't include this slide, that this strategy was anticipated by Claire Jean Kim in 1999. And she writes, valorizing Asian Americans relative to Blacks via the model minority myth permits conservatives, so this is what you were saying to some extent, permits conservatives to pursue racial retrenchment without appearing racist. When whites then side with Asian Americans in an effort to push back Black political demands, they can come across as anti-racist champions of the underdog rather than as acutely self-interested actors. This was 1999, and she was not wrong. Thank you.
Okay, thank you, Dr. Wong, for that talk, and for explaining so much about the actual social scientific evidence about affirmative action and Asian Americans, which, as you said, has gotten lost or misunderstood in a lot of the media reporting on this. And I think your talk should be required listening for the Supreme Court majority and the SFFA case. Alternatively, they could have paid attention to your brief or the factual findings from the district court. As someone who studies the courts, I'm sitting here thinking about how the trial court is where findings of fact are supposed to take place, and those findings of fact about there not being discrimination towards Asian Americans were actually apparently just ignored or overlooked by the Supreme Court. And I'm really glad you brought up Edward Bloom and his involvement here, because it's really striking to see one activist playing such a huge role, first in Shelby County versus Holder, and now in this case. I thought I would ask you first, before we take some other questions, hopefully from the audience, to what extent do you think the idea of the Asian penalty and the model minority myth among other problems with them ignore the distinctions among Asian Americans because both of those myths kind of operate on the idea that sort of all Asian Americans are the same, right? And you showed this list of the UC systems data, and you've got actually a number of different identities and various categories.
Yes, so the diversity within the Asian American community is always papered over by this idea that all Asian Americans are high achieving, high income. And one of the things we see is that those groups that have benefited most from employment visas, Chinese and Indians in particular, they are showing higher test scores. Why? Because US immigration law has actually recruited these communities for their high education levels, right? And so I'll just give you an example. Among Chinese, over 50% of Chinese immigrants to the US have a college degree. In China, that rate is more like 15%. Where are Asian values stronger? In China or here in the US, right? Also, if you look at, let's say, Vietnamese or Cambodians who do not have as many of those employment visas, who have not been recruited in the same way, they're scoring lower than many groups on Hmong Americans, right? They are scoring lower than almost any group sometimes on standardized tests. Do they have Asian values? Yeah, they are Asian American. So there is a lot of diversity within the Asian American community that is papered over by this myth. Just to throw in one more piece of research, there's two more pieces of research. When non-Asian Americans say that they endorse this idea of the model minority, when they say that Asian Americans are ultra competent and care a lot about education, that is associated with more anti-Black views and views that Black and Latino students need to work harder, right, to achieve equality. When Asian Americans internalize the model minority myth and they say that Asian Americans have a special value for education above and beyond other groups, that is associated with more anti-Black attitudes and opposition to affirmative action.
Okay, thank you. I want to give the audience a chance to ask questions since we don't have a ton of time left. Start in the back here.
Yeah, I have a question. Based on the wording of factor, do you see the Supreme Court ruling as a largely like superficial win or just a stepping stone to something much more big?
Not superficial. I think it is a huge, huge change. The fact that there could be an explicit factor and race could be considered was an important part of admissions. What I don't think, and what other research has shown, is that when you remove those factors, it actually doesn't really benefit Asian Americans very much. So even though this whole case was about Asian Americans, in California, after a proposition that banned affirmative action, Asian Americans didn't show, they ticked up a little bit in the most selective UCs, but they didn't show any meaningful increase in terms of post-graduation income or employment. But Black and Latino students in California, after affirmative action was banned, they were much less likely to be in the UCs. That's changed a bit because of more aggressive outreach. And there was a big generation-long decline in wages and in employment for those students. So the payoff is very little if you care about anti-Asian discrimination, which I don't think is at work here. But the lack of access for Black and Latino students is significant after these bans.
Other questions?
So we've been talking about Harvard a lot, and a lot of these cases focus around these really, really elite universities where there's intense competition to get in and very driven parents. I wonder if you would speak a little to how this affects non-elite universities, which is where most people go.
Very little in some ways. So there is this chilling effect, but it's important to know that these kinds of highly selective institutions are pretty rare in our society. So we have about a little over 200 universities, colleges and universities that actually use race conscious admissions. All the other universities are actually open enrollment. They do not have that kind of criteria. So it is really affecting a small proportion. I think there's more than like 4,000 universities. So it's really affecting a small proportion of universities. It's also important to know that 50%, 40 to 50% of Asian Americans also attend community college, not one of these institutions. So we're really talking about a very small group of people. That doesn't mean, however, that this case doesn't have implications. While I think it's really critical to hold the line, this group, SFFA, is likely to go after minority contracting. That will actually hurt Asian Americans a lot. And after lots of other kinds of ways, like corporate America, for instance, philanthropy. So the fact that they have this win is really just part of a broader strategy of defending the status quo in some ways and making sure that any kind of equity program is ruled unconstitutional. That's what we're seeing at the K through 12 level. What I was trying to show there is those are not race conscious admissions. That's not about affirmative action. Those are race neutral kinds of policies, like removing a fee to apply for a magnet school. That's what's being challenged at the lower levels.
Thank you.
Because, I'm an Asian American, and I'm not yet, so I'm a Chinese international student first, but I have a lot of Asian Americans, and they're deeply concerned about their students, their children's academic performance. And so I followed the rules very closely, and I read a lot of this. I totally agree with you that the Asian America as a minority, we hurt the Asian American community, but I found that the defense of the affirmative action from the perspective of Asian America is not so convincing. For example, in the lecture, you have highlighted like the Asian Americans have not been hurt by the Harvard, for example, Harvard admission rules. You showed how proportions of the Asian Americans have been selected into the Ivy League schools, but it doesn't mean we can have both, right? Disproportionately high group of Asian Americans have been selected into the Ivy League schools, but on the other hand, they could be, hurt on the other hand, because we have historical presidents of the Jewish students, all right? In the early 1920s, there are about 25% of the students in Harvard were Jewish students, but they were still targeted, unshamedly by the university leaderships. So so that's the kind of feeling I have got from the Asian American communities.
And you're not alone. So this is very interesting. When we see public opinion, because my day job is actually studying public opinion, right, among Asian Americans. And what we see is that for the last 12 years, about 70% of Asian American registered voters have said that they support affirmative action to ensure that Black women and other minorities have access to education, right? But Chinese Americans, and I'm also Chinese, are the group that's most suspicious of affirmative action. And they are the least likely to endorse affirmative action. They're the least supportive. It's still a pretty good chunk of people, but they're the least supportive. The person who wrote that book on Jewish Americans and discrimination at Harvard actually submitted a brief also to say this is not what's happening with Chinese Americans and Asian Americans. But I hear what you're saying. The thing is, most of what Chinese are saying, Chinese Americans, let's say on WeChat, is based on the idea that that their kids, Chinese Americans, are scoring higher on the test and that they are facing some kind of discrimination. But what I'm trying to say is that the test and the SAT is not necessarily the best measure of merit. And so when you use what could happen is maybe that test is not fair and it will be eliminated. And then you would not have those charts to begin with, to say that there's any kind of different, any kind of discrimination. At the base level, I don't believe that the SAT is a good measure of merit. I think it is just a barrier to admissions, and we'll probably differ on that.
No, wait, what I mean is you have highlighted the Asian America, because of their immigration background, is that right? 50% of the Asian America, especially Chinese America, were college educated. So I'm just wondering, can you find like a data like this? Like, for, just the funds, the freshmen enrollment based on this kind of family background, see whether, the Asian American.
The great majority of Asian Americans who have those high test scores are high income also. There are, of course, in every community, there are low income Chinese Americans, other groups that some do score higher, right? Same with other groups too. So I would say that if we're going to look at your typical Asian American, they are going to be more highly educated. They are going to have higher income, their parents, than the typical non-Asian American. That is true. That is, but I'm not saying that Asian Americans face no discrimination. My whole career has been tracing in Asian American studies discrimination against Asian Americans. I do not think this is the realm in which Asian Americans face discrimination. I think they are facing discrimination in corporate America, in stereotypes about the forever foreigner, in things like college leadership, for instance. But in this particular case, I don't think the evidence is there that they face discrimination. But most of the Chinese American community that I hear from does not agree with me. It's internalization of the model minority stereotype. And it's also, I think, an idea of like status. It's like system justification. It is benefiting them, and so they are afraid for a change. But change doesn't necessarily banning affirmative action is not going to have a huge effect on Asian Americans and Chinese Americans, in my view, in terms of their numbers. And those Chinese Americans who are really invested, if the SAT is eliminated, will be very upset.
Time for one more question.
Very impassioned speech, and I left me wondering how you balance kind of the activist side, what you want to happen in the Supreme Court, with your analysis side as a researcher, and how those two sides kind of either are in conflict with each other or work together.
Well, most of my academic research is actually not squarely on affirmative action. I do study public opinion, and so that's how I understand how different Asian American groups support affirmative action, for instance. I'm doing some research on why do Asian Americans and other groups, what are the kind of drivers in survey research or using experiments that predict whether or not they will support such a policy. And what I find is like it's partly ethnocentrism. So it's the idea that like our group is more worthy than other groups. And it's also anti-Black racism. It's not as much of a mystery as I had thought when I started doing this research. That is what's captured in the survey data that I see. So I can sometimes marry it, yes. And then I publish in academic journals, but these kinds of more advocacy pieces, I mainly write op-eds or other kinds of things.
Thank you so much. But join me in thanking two of the great
And Ms. Lawson will give you a quick piece of information, instruction about what is happening outside, and then we'll leave this room for some foods and activities.
I saw you studying amicus.
Hello, everyone. I know that I am the only thing standing in the way of you and food, so I will be brief. My name is Carice Lawson. I'm the coordinator for civic engagement in the Office of Civic Engagement and Social Responsibility. And what we really do is, believe that all of you want to make a change, but that happens through connecting with others, co-creating, transforming the world around us. And we really are on this university campus to help you build the skills and disposition to feel comfortable and confident doing that in your community here at Towson University, but also in the greater community beyond. So I am going to talk about a very quick activity that we have, which is really, I have taken the preamble of the Constitution and the first section of the 14th Amendment, since that is what we have been focusing on during our talks with our lovely panelists, which thank you so much for everything. I definitely feel like I learned a lot from both of you. And so that you can have a physical copy of it, and also have provided lots of beautiful colored pens and markers so that you can do something called a blackout poem. I don't know if any of you have done this before, but it takes from that idea of having something physical and then kind of using art or creativity to create something new. But instead, we're just using it as a way to highlight some of the things that you might notice in the Constitution that you want to highlight. So I've taken, as you can see, the preamble and then the first section of the 14th Amendment. And then I took my own marker to highlight the things that stood out to me as I was reading. So this is just something to have a physical copy of some of the things that we were talking about, but then you get to be a little bit creative and use lots of colors and hopefully use it as a launching piece for some conversation as we are in the reception, because we want really this to be a way for you to build community within this program, build connections with the people around you who are also passionate about talking about the same things as you. So with that, I am going to have the papers at the front with the markers, and you can take some of that as you go and get some food. Thank you so much.
Thank you so much.